Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh.
Well, we are at the end of the year, so we're going to do a look back and just cover some of the key topics in trade secrets and restrictive covenants that we saw over the course of this past year. We'll be looking at things that have happened in the context of restrictive covenant law, both at the state and federal level. We'll look at the Computer Fraud and Abuse Act, which we all thought was dead, but maybe it is, maybe it isn't. We'll see what was happening in the world of trade secrets, and we'll also cover AI with a special guest speaker whose name will not be disclosed until she appears when she appears, and we'll introduce her at the time. So why don't we kick off? I'll get us started talking about non-competes and what's happened in that world this past year. And let me start at the federal level, because I think there's been a lot of anxiety at the federal level and a lot of confusion at the federal level. And I think that all started with the FTC's non-compete rule from back in 2023 when they first started looking, when they issued their first proposed rule, and then later in 2024 when they actually issued the final rule. But the FTC, you may remember that they started looking at non-competes as far back as 2018. And then fast forward to, I believe it was 2000, 2000, right before COVID hit, they had an in-person workshop, full-day workshop where they talked about non-competes. They had a pretty stacked deck of people who were very hostile toward non-competes, who were talking all day long. They wound up having a further workshop at the end of, I think it was 2021, after the Biden administration had indicated its support for regulating non-competes and asking the FTC to work with Congress on that. Ultimately, the FTC decided not to work with Congress because Congress didn't want to work with the FTC, apparently. And so the FTC just went out on its own, issued a rule. And that rule would have banned non-competes nationally with very, very limited exceptions. Prospectively, they all would have been banned. Retroactively, it banned most of them. And the only exception in the final rule was for non-competes in the context of a sale of business. Those were the only ones that you could use going forward. They also were going to ban not just non-competes, but you may recall in the original proposed rule, there was a ban that would have covered what they were calling de facto non-competes. And that's any restrictive covenant, including a non-disclosure agreement, that could act like a non-compete because it was broad enough to preclude somebody from working at a competitive role. And they abandoned the de facto rule when they issued their final rule, and then just put in the exact same concepts, just didn't call it a de facto non-compete rule. And so, which was a little bit odd the way they went about doing that. So the bottom line was all non-competes were going to be gone. And as you could imagine, that got challenged. There were 4 suits, 2 of which were consolidated in Texas, and it wound up being 3 lawsuits, 1 in Texas, 1 in Pennsylvania, and 1 in Florida. The Texas case, I believe, went to PI first, and the court issued a preliminary injunction barring the enforcement of the non-compete. It wasn't quite clear how broadly that would sweep. The next case to hear the preliminary injunction motion was in Pennsylvania and Philadelphia, and the court, not surprisingly, found that the rule was perfectly valid and fully supported and well within the scope of the authority of the FTC. And then the third case was down in Florida, and the court issued a very narrow preliminary injunction precluding the FTC from enforcing the non-compete against the particular party. In that case, a lot of the similar reasoning to what came out in Texas was relied on by the court there, but it was a little bit less condemning of the rule, although it still did condemn the rule. At the end of the day, those got appealed. Well, the Philadelphia case got dropped, as it should never have been brought in the first place. The other two were appealed by the FTC. And then we had the change of administration. And when the change of administration happened, the FTC wound up issuing a statement saying that they are not really a believer in the rule, but they are believers in the authority of the FTC to regulate non-competes. And then what has happened since is that they have, in fact, regulated non-competes on an individualized basis, and they have abandoned their appeals. And that all happened within a series of days. And they were then also going to be focused on healthcare companies, both healthcare companies and healthcare staffing companies. It was a little ambiguous how they phrased it, but I think the takeaway was it was all in the healthcare industry. They had sent out letters to a number of these entities and have since disclosed who the entities were that they have sent those letters to, asking them basically to self-snitch and to report on their practices. They also asked people to submit, that is the public at large, to submit any information about any companies that they were aware of that were using non-competes or other restrictive covenants in a way that was unfair or abusive. Not their words, but that was the gist of it. And they received a whole bunch of letters in response to that and submissions in response to that. And they've also instituted a couple of enforcement actions, but the one that they announced publicly and the one that they have since concluded was against a national pet crematorium. They basically said that their use of non-competes for all their people was too much, and they needed to abandon them and apologize and do all those kinds of things, which they have since done. So
Yeah,
go ahead, Matt.
Russell, just coincidentally, I've been involved in a case involving pet euthanasia, and so it's been interesting to see that the FTC focusing on that industry in particular.
Your client would be well advised to review their non-competes, as I'm sure you have already told them.
Can I just note that this
Yeah.
is sort of a grim, these are a couple of grim business lines that we're discussing here in the midst of a holiday joyous season.
I'd like to, right. We got to get everybody, down
Yeah.
down before the levity of the holidays.
That's a good sell. You're good on your feet. There's no doubt about that.
So the takeaway was the FTC is doing individualized actions. And if you have clients or you are in-house counsel or HR in-house, whoever, whatever your connection is to employers, you do really want to be looking at what types of agreements they're using and the need to be using them for the people that they are using them for. There's no question that using non-competes in certain contexts is critical for the protection of your trade secrets, your confidential information, your customer relationships, and the stability of your workforce to some extent. But what's not appropriate is using them for people who you really don't need them for. And so companies really should be looking at that and looking hard because the FTC is coming. Not only is the FTC coming, but the NLRB is coming as well. Just very quick history on the NLRB. You will remember that Jennifer Abruzzo, who was the general counsel, no longer the general counsel after the change of administration, but while she was there, she issued two memos, one that said non-competes were an unfair labor practice, and it wasn't just non-competes, but again, it was basically de facto non-competes. And then she also said that so-called traps, those training repayment agreements, were also unfair labor practices. She left, those memos were withdrawn, and everything looked like the NLRB was going to be uninvolved in this area until recently when the NLRB just told Amazon that its agreements are all unfair labor practices, and it struck non-competes, non-solicits, no recruits, and confidentiality agreements. This is the tip of the iceberg for what we're going to be seeing at the NLRB and the FTC. So companies really need to be paying attention to that. There's another case brought by the NLRB in Michigan. Now, this was just at the ALJ stage. So we'll see if the NLRB, which obviously we think has changed political winds, we'll see if they reverse course on this, because otherwise this was pretty consistent with the former general counsel, Jennifer Abruzzo's memos. We'll see. I don't know. The other thing that's happening is, the perennial bill or bills in the Congress to ban non-competes. There's a bill that's pending there again by the same suspects, the same senators and reps. And so we'll see if that really goes anywhere. It probably won't, but it might, and you just need to keep an eye on that. That's all at the federal level. At the state level, in the meantime, there were, every year for the past several years, there have been anywhere from 60 some odd bills, which I think was back in like 2016, 17, something like that. After Jimmy John's in 2014, you wound up seeing more and more and more states that were looking to modify their restrictive covenant laws. And this year, there were a total of 102 bills in 37 states, 19 of them related to low wage bans. You can't use non-competes for people earning less than a certain wage or other criteria, wage-related criteria. 16 of them, only 16 of the 102 proposed a ban, but 44 of them were in the healthcare space. So you see the healthcare space really is both at the federal level and the state level. This year, there were 13 new laws in 11 states. There was Arizona, California, which was sort of related. It was more about hedge funds and physicians. Colorado, Florida, Indiana, Montana, Oregon, Texas, Utah, Wyoming, and Virginia. Various bills. Most of them were healthcare. Not all, but most healthcare. The one that I thought, though, was probably, well, actually, before I get to that one, in Wyoming did a weird thing with their law. They actually made it much, much, much harder to enforce non-competes, but they went to the law that Colorado basically just abandoned recently. I think it was last year. Basically, you could only use non-competes for executives and their administrative assistants and some other people of that ilk. Colorado abandoned that. And now Wyoming has adopted it. So we'll see how that plays out there. Virginia just added another category of low wage. Anyone who's not exempt under the Fair Labor Standards Act can't be subject to a non-compete. So if you're not exempt, you're exempt from non-competes. And then Kansas did something odd because they went even further and started restricting non-solicits and no recruits. So that was a new one too. But the one that was, I think, most surprising for everybody was Florida. Florida has always been at the opposite end of the spectrum from California when we talk about the enforcement of non-competes. California, a complete ban. Since 1872, in theory, they had a ban. It really was much more recent, but 1872. Florida, on the other hand, never met a non-compete that it didn't like. And now you can have non-competes that will last and restrict the employee for up to 4 years. And not only can you have a 4-year non-compete, but the court must enforce the non-compete at the preliminary injunction stage. There is no basis for the court to not enforce it in the first instance, absent some very, very, very limited circumstances. Now, the individual needs to be someone who earns 2 times the annual mean wage of the county in which the company is based, or if the company isn't based there, then the annual mean wage of the county in which the employee resides. Here's one question. What if you have a Florida company with an employee outside of Florida? Well, it's called the Choice Act. It stands for Contracts Honoring Opportunity, Investment, Confidentiality, and Economic Growth Act.
Hilarious.
It is hilarious, right? And they're actually in the preamble to it, which is, says that basically non-competes are important to protect opportunity, investment, confidentiality, and economic growth, which is exactly the opposite of what the FTC has found. No surprise. I think the truth probably lies somewhere in the middle, but it's for another day, not for a year in review. The question, though, is a Florida company with employees out of state, what will happen? And I suspect what we're going to see is a lot of races to the courthouse. I think you're going to see companies suing in Florida. They're going to try to enforce their non-competes there and hail the person from whatever state they're in into Florida. And I think you're going to see employees who are in other states run into court in those other states and say, hey, uh, Florida law is repugnant to the law of this state, the public policy of this state, and therefore this agreement should be void ab initio. And I think, that worked under the old Florida law in New York. New York had already had a decision from, I think it was the Intermediate Appellate Court. It might have been the Court of Appeals, which is the highest court in New York. I just can't recall offhand. It was Brown and Brown versus Johnson, I think. And in that case, it rejected the application of Florida non-compete law as obnoxious, that was the word, to New York public policy. And so, Florida's obviously gotten more obnoxious now. And so then the question is, will it be enforced in any other state? We'll see. So that is pretty much the key updates at a broad level on the non-compete side.
Well,
And
Russell, I think you
yeah,
missed. I think you missed one though. It's a big
what did
one
I miss?
for you, which is that I think as many our listeners know, Lena Khan was the driving force behind the FTC rule, right?
Yeah,
And
yes.
I thought maybe you didn't mention her name because I know some people consider her like Voldemort, the name that shall not be mentioned. But the interesting thing is that she is now, I believe, the chief of staff for the new mayor in New York City, Mamdani.
Yeah, Mayor Mandami, yeah.
And I at least, I know you and I and other friends of ours have been emailing about the question of whether it could, well, we know that New York, a couple of years ago, the General Assembly passed a non-compete ban that was pretty broad. And, the governor was about to sign it when I think the lobbying forces convinced her not to. But the question in my mind is, could New York City pass a ban on non-competes? And I understand from lawyers in New York that that is actually something the city could do. In other words, like I think here in Georgia, the city of Atlanta could not pass a law like that. I think it's reserved for the state legislature, but in New York, that's not the case. And so I'm sure that the mayor and Ms. Khan have a lot of other priorities in New York City, but I wouldn't be surprised to see some effort at the city level to ban non-competes, because that certainly is a something we know that she's a warrior about, and in the position she's in, certainly has the ability to influence that policy.
I could not agree more. And in fact, over the past several years, there have been bills in the New York City Council to ban non-competes. They haven't gone anywhere. I don't know whether the city can pass a ban if ultimately the state says no. And that's, I think, the one piece, right? Because my understanding is like yours. The city has some inherent power to pass certain laws, but I'm not sure if there's a mechanism, and I think there might be. I think maybe John Barry may have mentioned this. Somebody I thought had
Yeah,
mentioned.
it was John,
Was
right?
it John? There may have been a mechanism for the state government to preclude that from happening, and we know that it's something that the New York legislature is interested in, but Governor Hochul has been reluctant to do a full ban. I think she's more willing to do a wage threshold, which would be pretty high, but I don't think she's ready for a full ban. So if the city tries that, I don't know what will wind up happening ultimately.
Yeah, and I do think what John mentioned is that the mayor couldn't do it unilaterally, of course. The city council would have to
Yeah,
ultimately vote on it as well, assuming that it was permissible by the state. But
right. Well, but
yeah,
the city
unless you
council did, right? I mean, the city council has done that in the past. They've tried in the past.
right. Yeah, to follow up, I mean, if this is a good time, I was going to maybe talk about some takeaways in light
Yeah.
of everything that has happened. What should we, our clients, be doing with respect to their restrictive covenant agreements, particularly those that have employees in more than one state? And so I think that, the starting point is, this is not something where you can draft agreements, implement them, and then not worry about them again, right? That at least on an annual basis, if not more often, looking at them as states implement things like we've been talking about, wage thresholds, notice requirements that the employee be informed that they should retain counsel or have the opportunity to retain counsel, things like that, that I think we're going to continue to see, even if we don't see more full bans like we saw in Minnesota. I think we're going to continue to see these other requirements that need to be considered on a state-by-state basis. The wage limitations are a big one, but then like we talked about and alluded to, these industry bans, states passing specific bans in specific industries, whether it's healthcare, veterinary medicine, broadcasting, and things of that nature. One that's always existed, but I think that also is being addressed by some states is compensation. Is there some consideration requirement beyond continued employment, and making sure that if you're rolling out new agreements or updated agreements, that you're complying with whatever requirements exist in the states where employees are located with respect to that. The timing and notice requirements, making sure that you're complying with what each individual state says about how much advance notice you have to give an employee or a prospective employee that they'll be required to sign a non-compete or another restrictive covenant. And then the other thing that we've talked a little bit about in the past, and I think is important, is really understanding that there's risk beyond just your agreement not being enforced, right? In some states, in California and others, there are risks to implementing or attempting to implement agreements that don't comply, where there are penalties and injunctions, and even theoretically in Colorado, criminal prosecution that could occur if you try to implement an agreement that does not meet the state law. So I think that it's the big takeaway is, like with anything else, having maybe a New Year's resolution to review your agreements and make sure that they're compliant. And if they're not, doing what you can to update them and to address the specific requirements from state to state where you have employees.
I agree with that. I think the other takeaways are, number one, start looking at other types of agreements that really haven't been specifically addressed, or maybe they were addressed by the FTC's rule, but they haven't been addressed in other states. So just at a top level, you've got confidentiality agreements. Anybody who has access to trade secrets or other confidential business information should be subject to a confidentiality agreement without exception. There are instances where it doesn't happen, and mistakes happen. Unsophisticated companies don't necessarily realize that. They will oftentimes be permitted to skate by on that, but you really do need to make sure that you're using confidentiality agreements and make sure that they don't cut too broadly, because we are seeing the federal government, the FTC was at least, and we'll see if it still does, the NLRB is, and some states are starting to crack down on confidentiality agreements that cut too broadly. So you really just need to focus on the language. There has been a thing that I have been toying with for quite a while, multiple years, never needed to use it, but maybe now this is a time to start thinking about them. And we're still working on the name. I think this has been years. We can't come up with a good name. John always comes up with good names for things. So John, you can come up with a name. But
I like are we going to talk about
no.
non-compete?
No. We'll get to that in a minute. We'll get to that in a second. Yeah. No,
I think that's a perfectly good name.
Well, you also suggested timeout non-compete. Well, I'll talk about it now, and then we'll come back. I'll come back to the other.
Sorry to take you out of order.
No, well, it's I can't think if I'm not in order, right? So let's talk about springing non-competes. The concept is the employee does not have a non-compete, but in their agreement, you will provide that if the employee violates their non-disclosure obligations, their non-solicit obligations, their no recruit obligations, or if they misappropriate information on the way out the door, whatever it may be, something that indicates they are not trustworthy and cannot be relied upon to govern themselves according to their restrictions, then as a remedy for that, you're asking the court to impose what is effectively a non-compete. That's provided for in the Massachusetts statute. I think it's also in Rhode Island, because I know they copied a lot of the language out of the Mass statute. And so that's something I think companies should be thinking about, right? It seems fair to everybody, as long as everybody plays by the rules and we don't need a non-compete, make sure you behave yourself. And then if you don't behave yourself, well, you've just shown that we really do need a non-compete for you. So now here it is. What I was looking at though, John, was right now the phrase that I'm using is either pay to not play agreements or stand down incentive agreements. And the concept is right now, a very common type of restriction is a forfeiture provision. So you can go compete, but if you do, you're going to forfeit something that you were otherwise entitled to. And the FTC has been very clear that is not going to be enforceable. And a lot of states view that as a non-compete because you're giving up something you're already entitled to. So I thought about turning it on its head. If you choose not to compete, we will pay you some amount of money, right? You're free to compete. You're not entitled to anything. We're not taking anything back. But if you choose to not do it, we'll pay you, just like if we're paying you to be employed. And so we'll see if that winds up working. Obviously, it's all by agreement, right? I mean, it's got to be enough money that they're incentivized to not compete. But a court very well could say that that really is a non-compete. And, it's basically a forfeiture for competition in disguise. But I don't think it is. I think it's fundamentally different, right? It's like the difference in a condition precedent and a condition.
Condition subsequent.
Thank you. Thank you.
So how does that differ from a garden leave? Maybe I'm missing the nuance there, Russell.
So you're not actually working. With garden leave, you're working, right? And with garden leave, if it's so the real garden leave, you're working during the time. It's just an extended notice period. In the garden leave, the way it's used in Massachusetts, and the way a lot of states and the federal government has started using it now is that you're not working, but you're being paid. So a paid for non-compete, right? Paid during the restricted period as opposed to being paid in anticipation of the restricted period. And so the idea is that you are restricted. There is a prohibition on you competing. Whereas in this other context, you can go compete. You're free to do it. It's just that if you do, you're not breaching anything. If you do, we're not going to pay you this extra money that we would have otherwise been willing to pay you.
So it's basically incentivizing an employee as opposed to imposing it through it's a voluntary
It's voluntary,
opportunity, if you will.
yes. Yes.
Okay.
There you go.
Yeah,
So right now we have stand down incentive agreement. Could make it stand down opportunity agreement.
Opportunity agreement.
Yeah.
We've been using all sorts of ridiculous acronyms.
The challenge with that, Russell, I think legally I like it, and I like being in court making that argument. I think as a practical matter, getting companies to agree that they're going to pay people who are no longer working for them to sit on the sidelines, that's often a tall order. And maybe a future episode we did years ago a breakfast briefing for our clients on sort of alternatives to restrictive covenants, and we had like comp experts come in and talk about, look, here's how you pay your people well and keep them happy so that they aren't looking to move to a competitor. That's, to me, always one of the things that I think companies really ought to be looking at in the first instance, right? How do we motivate our people, pay them well, and avoid the situation where they want to leave and go to a competitor? Now, you can't avoid it in all circumstances, but you can certainly reduce it. And we all seen it, right? We've all been on the other side of the case where the company that is treating their people horribly, cut back on sales commissions, they're bleeding employees, everybody's jumping ship because they're being treated so poorly, and the company's running into court trying to stop them. And you're like, come on, judge. Like if they hadn't, reduced my client's compensation by 50%, he would never have left to go to a competitor.
Did you have lunch with Lena Khan? No, I totally agree.
I think it's just good business.
Right? I actually agree.
That was a cheap shot.
I know, wasn't it? It was cutting him off at the knees, right? It was.
Wait a minute.
All he was doing was advocating for taking care of your employees.
I actually
with that Grinch-like heart the size of a walnut. Took him out.
It's pre-Christmas, pre-New Year's. I think once those holidays hit, I will be all in favor of treating your employees properly. No,
wait a minute. I
totally kidding. I totally agree.
We as lawyers, we can't have non-competes with our partners, our associates, our counsel, et cetera, right? It's unethical in just about every state in the country. And somehow we as businesses, survive through that. And the way we do it is by paying our people well, treating them right. And if you don't, and someone leaves, they have the right to take whatever clients with them that they want, or that the clients want to follow them. So I'm not suggesting that's true in every business. All I'm saying is that's a critical component that I think we often overlook when we're talking about the legalities and all of these issues around bans or not bans, et cetera.
So I Actually, totally agree. The one thing I will say about the lawyers, though, is that it's not our interests that take priority. It's the client's interests, right? So in the customers, that makes sense like in a healthcare concept, right? Where healthcare companies, you got to prioritize the patient. Here, and for lawyers, you got to prioritize the clients. But when you're talking about salespeople selling widgets, we're going to prioritize the keeping the business in business, right? And not letting, because you remember the impact of somebody leaving and taking their clients in the context of a law firm can actually be the demise of law firms. I mean, we've seen that happen, and it could be the demise of companies. So if companies are paying somebody to do all of this work, paying them to develop those relationships, paying for the enhancement of the relationships, and the customers think that it's all this salesperson who's been so nice to wine and dine them, well, you got to protect the company in that context.
Yeah, but I think that, and I talk about that all the time. And in the state of Georgia, the public has the absolute right to choose their lawyer. That's why we have that ethical rule. But you don't have the absolute right to choose your doctor because non-competes are perfectly legal in the healthcare professions here in Georgia, which to me, as proud as I am of what I do, and I love what I do, I find there to be a inherent sort of contradiction there that
I do
doesn't
too.
really make sense from a policy standpoint. And I think
I agree with you.
and candidly, I think it goes beyond just law firms and healthcare. I think any professional services environment, whether it's insurance or staffing or, some of these things where they're really, there are real questions about whether someone has access to information that's truly a trade secret, and that kind of thing. In the professional services world, I think that the argument can be made that they're much less appropriate. It's much less appropriate to have a non-compete for the same reason it is in our business.
So I think this should be a topic that we should cover because there are arguments on both sides of this and very legitimate arguments on both sides of this. But given the nature of today and given the fact that we could probably talk about this for another hour, let's pause this, save it for another one, and turn back to the year in review. And our guest speaker has just arrived. So why don't
Perfect segue.
Yes, it's perfect. We'll let her in now.
Gentlemen.
Welcome, Sarah Tischler, partner at my law firm and AI in the law expert. Sarah has agreed to help us out here as we're covering the topic of AI, since she has been staying on top of all of the developments in this area.
Good times. Thanks for having me.
Yeah, thanks for coming. So why don't you kick us off with the topic of AI and our year in review?
Sounds great. This year has been a really exciting year for the intersection of AI and trade secret law. There is not only a ton of litigation happening in the AI industry that's specific to trade secret issues, but there are also very interesting developments in the body of trade secret law itself that are being impacted and going to continue to be impacted by AI as a concept, as a tool. So turning first towards some of the major cases coming out of the AI industry, I think there are two really interesting high-profile cases that are worth touching upon. One is the Open Evidence versus Doximity case, which is pending in the District of Massachusetts. This is a case that focuses on whether prompt injection queries could constitute trade secret misappropriation. The complaint has really framed this situation as a cyber attack aimed at reverse engineering the confidential features of Open Evidence's model. And this is all about, I should have mentioned, an AI-powered medical chatbot. So basically, the complaint alleges that queries such as repeat your rules and summarize your rules are actually illegal and aimed at misappropriating the trade secrets inherent to this AI medical chatbot. And this is all the part of the question of what it means to reverse engineer and whether or not this is fair game or whether this is actually something that should be considered illegal under trade secret law. So that's number one. Number two is it's actually a group of cases at this point that are being brought by XAI, formerly known as Twitter. This is the AI branch of the X universe, Elon Musk's universe. And they've brought suit against OpenAI, an individual named Lee, and an individual named Freicher. I think I'm pronouncing the last one right. The first two are in the United States. They're pending in the Northern District of California. And the last one is actually being brought in the United Kingdom. Freicher is a UK national. And this group of cases alleges trade secret misappropriation by these two individuals, but also by OpenAI. And the allegation is that they're trying to take XAI's crown jewels, the source code. I was just looking at the reply brief actually in the XAI versus Lee case, and there are some additional allegations that have been raised in there about what Lee was able to abscond with. They're alleging that he took the entirety of XAI's code base for its flagship Grok product. That's a direct quote. This was filed 3 days ago. And in particular, the Lee case is very fast paced and touches on a number of different topics that are pertinent to trade secret law and trade secret misappropriation, including now a criminal referral and investigation that's ongoing. So Mr. Lee has raised Fifth Amendment issues in response to some of the expedited discovery that's been ordered. And this case is showing no signs of slowing down anytime soon. It is definitely one that touches on all kinds of different considerations that are pertinent to this body of law. And with that, I think looking forward to how AI I'm sorry, go ahead, John.
Because one thing that I found really interesting, and you pointed this out to me in the open evidence cases, was really the alleged misappropriation. If I'm getting this wrong, let me know if I'm confusing one of the open evidence cases, but it was really it's the violation of the terms of use that are giving rise to the alleged misappropriation. Is that right?
Yeah, that's part of it. That's definitely part of it.
Because it was the attestation and the ban on reverse engineering, which I found really interesting because those are provisions that many people find in their terms of service and sometimes in their agreements, and to some extent, what are those enforceable, and do they give rise to a viable claim of misappropriation? To me, that's what I found really interesting, aside from the fascinating technology.
Yeah, no, that's an excellent point. As Russell knows, I love the issue of what happens when you have a contractual provision and a statute addressing the same conduct. It's one of my pet favorites. Hopefully, I'll have enough time to write a fuller law review article about it in the not too distant future. But no, it's a really interesting question. And just the question of reverse engineering in general with respect to AI, I think is going to continue to be important. As some professors have pointed out, the entire body of law as a concept up to this point pretty much conceived of humans thinking and doing intellectual work. So the concept of what is readily ascertainable was conceived of as a human figuring that out. And sure, this standard has changed over time with respect to the ability to use the internet to do searches, as opposed to, in the case of, let's say, a customer list, needing to manually go through a phone book and look things up yourself. But in the case, I find the case of a customer list so interesting because in many jurisdictions, that can be a protectable trade secret. But now you have a situation where I can go onto ChatGPT agent and tell it to create a customer list of certain parameters, press go make myself a nice coffee, come back to my desk, and it'll have it ready. So could we really call that a trade secret anymore if that's all it takes? I'm not so sure about that. No, to my knowledge, no court has addressed that particular issue, but I think as AI becomes more embedded and more powerful, you will see courts starting to take a narrower view of what kinds of information can be protected.
So to me, it seems like the combination trade secret really could be the most at risk, like a customer list that is composed potentially of all public elements that are assembled in a way that gives value greater than it's the sum of the parts argument. But that seems to me that type of trade secret is the one that's going to be most at risk once AI is being more and more utilized.
Yeah, absolutely.
All right. Well, thank you for that, Sarah. Thanks for joining us. And we
For
will
sure.
we will certainly keep our eyes open for your law review article and your other blog posts on the topic. Thank you
Sounds
for
good.
staying.
And just one parting thought. Something that I like to spread the word about as a practical consideration for litigators in this space is including AI-focused discovery requests in your papers. If you aren't already, people are using ChatGPT, Gemini, Claude, you name it, as their personal assistant. They are having conversations with them as if they are a person. I would be willing to bet that in 99% of cases that are arising these days, there's going to be discoverable information in the chat history of one of these platforms. And it's not protected. It's 1000% discoverable. And you will probably find some very interesting information for your case. So if you aren't already including those in your request for production and interrogatories, I strongly encourage you to do so. So that's my hot tip for 2026.
Great.
ChatGPT, how do I wipe my computer to hide my misappropriation of trade secrets?
Yep. Does XYZ count as misappropriation?
Well,
Good
thank you again,
question.
Sarah. We will keep our eyes posted for all your updates.
Sounds good. Thank you, gentlemen.
Thanks.
Thank you.
Thanks, Sarah. Not surprising she'd have brilliant insights having gone to Duke. Makes sense.
We don't hold that against her. All right, so let me turn to then the Computer Fraud and Abuse Act. Just a very quick update. You may remember that the Computer Fraud and Abuse Act is a federal statute. I think it was passed in 1986 after war games, in response to war games, which, for those of you who haven't seen it, look it up. Basically, it was a hack that allowed somebody to accidentally get into NORAD and maybe cause World War III. That actually spooked Congress. They passed this law that said no hacking. And over the years, it's just been interpreted more and more broadly. And there was a split in the circuits about essentially whether an employee who uses their access to computer information in a way that was not authorized by their employer, whether that would give rise to a claim under the Computer Fraud and Abuse Act. And that actually was very frequently what we used before the Defend Trade Secrets Act got passed in order to get into federal court. Well, a couple of years ago, the Supreme Court addressed the issue and said, look, your purpose in accessing the information doesn't matter. If you're able to access the information, then you're not going to have a Computer Fraud and Abuse Act claim. We're not going to let your intent be the reason that a Computer Fraud and Abuse Act claim rises and falls. Intent based on your breach of your fiduciary duties.
Yeah, if you're able to access it legally, for example, an employee accessing information in the company's systems, that regardless of whether they're doing it for an improper purpose, that they did have access to it. They didn't have to hack in to get to it, or hack into a different part of the system that they did not have lawful access to.
Right. The gates up, gates down kind of thing, right? If the gates are up and you break in, that's a problem. If the gates are down and you go wherever you want to go and you're not supposed to be there, well, that's on the company. So we all thought the Computer Fraud and Abuse Act was dead between that decision and between the Defend Trade Secrets Act, but sometimes it would come in handy. And in fact, that's what happened in a case in the Third Circuit, where in a debt collection firm, someone was actually out sick and they asked somebody in the company to use the username and password of the person who was out in order to access some part of the network that the person who was out had access to. And fast forward, because of some issues that arose, the company winds up bringing a Computer Fraud and Abuse Act claim against these individuals for basically misusing their passwords. And this was a case in the Third Circuit. It was NRA Group versus Durenlau. The court below said, no, 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 there's no Computer Fraud and Abuse Act claim here. See Van Buren, basically. And it went up to the Third Circuit, and the Third Circuit said, yeah, the district court was right. There's no claim here just because you violated the policy, or you violated the restrictions that the company had placed on you, not mechanical or not electronic restrictions, but just they told you not to do something and you did it. That's not going to give rise to a Computer Fraud and Abuse Act claim. So the other thing, and I think the way the court expressed it was the breach of a policy is not going to be a federal crime. So we really are seeing that the Computer Fraud and Abuse Act is still, as we thought it was, not going to be giving rise to federal claims that really have a criminal component to them as well. The other thing that the court said that I thought was really interesting was that passwords are not trade secrets. So, because one of the issues here was the company said, well, you had our password in that, and then you misused our password. Well, you've misappropriated our trade secrets because that gave you access to all the information that was in the database. And Ben, I know you and I had discussed that a bit, and I think we're probably in agreement. You want to give your response to the Third Circuit on that and tell them why they may be wrong?
Yeah, no, I think that was a surprising part of the ruling. I think
Yeah.
that, certainly if you just look at, sort of definitionally going through whether it's the DTSA or pretty much any version of the UTSA, I think passwords absolutely qualify. And I think that, someone like Jim Pooley, who has a very expansive view of what constitutes a trade secret, would probably vehemently disagree with the Third Circuit on that. So that part was surprising. I don't remember reading in detail the rationale for why the court found it's not a trade secret, but I would certainly believe that you can make a very plausible and should be winning argument that passwords are trade secrets.
I agree. The court said it had no inherent value. The value was in the access. But the fact is, you can buy and sell passwords. I mean, you go, not that I would do it, and I am absolutely not advocating that anybody do it. But you can go on the dark web and buy passwords, right? I mean, that's the whole thing that we're all worried about. And so I don't know how you say that doesn't have value, right?
Right. And the value is that it's like saying the key to your house doesn't have any value. I mean, well, first of all, it does have some nominal value. It costs you a couple bucks to get one made. But two, the value is what it allows you to gain access to,
Right. Exactly.
which is highly valuable. So
I agree. So, well, can you write to the Third Circuit, tell them to listen to this?
Yeah, relatedly, and I know we're running long on time, but I think, we've talked about doing a segment on this on its own, but, here in Georgia, we have the Georgia Computer Systems Protection Act, which is a mini version of the CFAA state law. It has criminal penalties, civil remedies, but it has been interpreted by the Georgia courts to very clearly apply in the context of someone taking or doing something with information they're not supposed to do in the employment context. And I always wonder why more states don't have a similar statute. And I think that there is real value in it in terms of deterring the kind of conduct that we see all the time in our cases and providing additional remedies. And again, going back to Jim Pooley, Jim doesn't believe that there really is much confidential proprietary information that doesn't actually constitute a trade secret. But as we know, as a practical matter, many courts do look at sort of more mundane business information and say that it does not, hate to use the word rise to the level of, but qualify as a trade secret. And,
Sorry, Jim.
there shouldn't be any remedy for its theft or its misuse. And I think that's these statutes, that if the CFAA had been interpreted to cover it, and where something like the Georgia Computer Systems Protection Act does provide additional remedies when that happens.
Yeah, there are a handful of states with similar types of statutes, and I do think that there is value in those. Obviously, we don't want to turn every time that somebody violates a policy into some sort of criminal act. But on the other hand, companies do need to have protection when they put these rules in place and employees don't follow them, and it costs the company significant harm. So, okay, that just takes us to our last topic then, just the developments in the space of trade secret law. John, can you walk us through some of the changes? Developments, I'm sorry.
Yeah, no, I'd be happy to. One thing that I wrote about, I don't know if it was 3 years ago, 2 years ago, was my observation that there were more and more large verdicts that were going to juries, damages cases that have been traditionally sort of the province of patent litigation, these enormous verdicts against other businesses that were alleged to have engaged in some infringement of some patent, and how trade secret litigation seemed to be shifting, at least in maybe not the majority of cases, but in with significant cases, that there was a paradigm shift in trade secret litigation. Perhaps the best place to start is what I've described as the old regime. And this is what I think many of the listeners who have practiced in this space would recognize as a trade secret case, a typical trade secret case that took place 15, 20 years ago. It involved an employee in a dispute with his or her former employer. Generally, there was a restrictive covenant that was involved. The employer was seeking an injunction. That was the preferred remedy because at the end of the day, the employee's not going to be able to satisfy a significant judgment or provide some sort of compensation for the loss of the trade secrets in question. And they generally were filed in state court. The Uniform Trade Secret Act being in place in the vast majority of states was the preferred mechanism. And what I've posited is that there's increasingly a new regime. Again, not dominant yet, but increasingly significant given the stakes that are in play for the parties in these cases. This new regime is more business to business. Vendors versus customers seems to be a preferred avenue for these trade secret disputes. The Coda versus Goodyear case, the Versada versus Ford case, those are sort of the paradigms of these new disputes that are being filed. Corporate espionage, again, business to business cases where there isn't necessarily an employee that's involved. The Pegasystems case is the $2 billion verdict that came out of Fairfax, Virginia, arose not by virtue of the departure of an employee taking things or a team of employees. It was a concerted effort by that business to engage in corporate espionage and pry into the trade secrets using the proper means of its competitor. So just by way of example, and I want to tip my hat to Vicki Cundiff here because she's compiled a chart that I've looked at and relied on that's just remarkable in terms of listing the number of very significant verdicts. And I'm just going to, these go back to 2020, and they still may not be the majority of cases, but the impact on companies that are ensnared in this type of litigation can be just devastating. $2 billion against Pegasystems, that case I mentioned a moment ago, that has been reversed by a court of appeals based on some jury instructions that they deemed to be improper. But again, a $2 billion verdict that took place in 2023. $756 million against Hytera, a Chinese competitor of Motorola. That was tried in 2020 in the Northern District of Illinois. It has been reduced through a series of different appeals, but a large part of the verdict remains. $605 million against Phillips 66 last year in a California state court. And in the summer of this year, the trial court imposed north of $200 million in exemplary damages for a total amount of $800 million. $222 million against Walmart this spring in the District Court of Arkansas. $452 million against EOFlow in the District Court of Massachusetts. Russell probably can speak to that case better than I, since that happened in his backyard. I mentioned the verdict against Ford, $105 million brought by its vendor Versada, and a $65 million verdict that I'll talk a little bit about that was brought by a vendor Coda against Goodyear. These are just frankly staggering verdicts, and they're only I'll say a fraction of a number of these verdicts that are still in the works in different parts of the litigation digestive system, if you will. So what are the dynamics that are contributing to these large verdicts? In my judgment, there are several things that are contributing to it. First and foremost, issues of fact preclude summary judgment. As many of you are aware, trade secret cases are difficult cases to get summary judgment on. A number of the elements present genuine issues of fact or are traditionally within the province of the fact finder, which is the jury. And as a result, they can be tough to dispose of at that stage. But I think one of the most significant aspects of trade secret litigation is the fact that plaintiffs are really predisposed to it. I've seen reported in two places, one most recently in Stout's Trends in Trade Secret Litigation report from last year, that 80% of the trial verdicts, think about that, 80% favored plaintiffs. I mean, I just think that's a remarkable number, and it speaks to the power of the story that generally accompanies trade secret litigation in terms of right and wrong, betrayal, theft, appeals that have very strong resonance with the finders of fact. I'm going to do a quick aside for those of you that find yourself gearing up for a trade secret lawsuit and that is likely to go before a jury that involves a damages award. Take a look at the consultant DOR, DOAR, their report last year on sort of the demographics that can shape a jury, and I think it'll be really helpful in voir dire to find out how certain people react to different allegations or questions that are posed by trade secret cases. And it's a fascinating read for those of you that are going to be heading in that direction. Finally, I think another really prominent issue that needs to be addressed and is still evolving, frankly, is the theory of damages. And I know Ben can speak to this, having tried a case in California that involved a significant claim for damages. But unjust enrichment damages are really becoming the dominant form or method of damages in trade secret cases. And unlike patent cases where you've got a settled standard like the Georgia Pacific standard that works through a hypothetical licensing agreement that was negotiated, there really is no set standard, and it gives great flexibility to a plaintiff to come up with a creative theory in a case that is predisposed to be well received by a jury. And this lack of a standard is creating some havoc at the federal circuit level. You've got a current circuit split now over whether avoided costs can qualify as damages. You've got the Second Circuit saying that they can't, based on the reasoning of their Sintel versus Triceto case that was, I believe, issued in 2023. And then you've got the Seventh Circuit, and the leading case there is that the Epic Systems versus Todd Consulting, which embraces or endorses an avoided cost theory. So we're sort of in a nascent stage in terms of this form of trade secret litigation. Again, not dominant in terms of the numbers, but given the impact that it can have on a company, I think it's something that we've got to be really mindful of. And I think we've got to reorient the way we look at trade secret cases, again, because under the old regime, we've been focused on onboarding and offboarding of employees and what we need to do, how we need to counsel our clients, and what they should be doing to ensure that their trade secrets don't go out the door, or that those trade secrets don't improperly accompany a new hire. I think companies need to start looking more broadly, more holistically at other potential places where these trade secret disputes can arise, in situations involving employees that are working with vendors and maybe not in compliance with their non-disclosure agreements, and or more assertive or aggressive about what they think is confidential and not confidential. So probably requires better training and better procedures when you are separating from a vendor, for example, to ensure that there aren't entanglements that could lead to a very large and very costly trade secret dispute. And frankly, a greater emphasis on business ethics. Russell and Ben, you may remember we had someone from Eli Lilly spoke at the AI Play Spring meeting about 10 years ago. And it was his job to make sure that Eli Lilly and its employees were behaving appropriately when they were conducting competitive intelligence. And for larger companies that have the resources to do that, that's something that they should be giving greater attention to, and making sure that those messages are being disseminated throughout the company. In terms of takeaways for potential plaintiffs, litigation funding, which is obviously a very hot topic. Many of these are classic David and Goliath situations with a smaller vendor against a very large Fortune 500 or Fortune 100 company. And litigation funding has been a game changer in terms of allowing those companies to bring those claims and manage the heavy costs that accompany trade secret litigation. And finally, being prepared for post-trial motions. Even though I've talked about a lot of these very substantial verdicts, by my rough math, based on the review of Vicky's chart and just following generally what's been going on, more than half of these verdicts are reduced significantly or thrown out either by the trial court or the Court of Appeals. So it bodes well for a plaintiff to be reasonable in its request and make sure that they button down the things they need to button down with their damages expert and the evidentiary proof giving rise to those claims. So I know that's a mouthful, but that's something that I've just been very attuned to as I've watched what's been going on with some of these really large verdicts that are eye-popping.
Yeah, I mean, John, you didn't mention the Prismian Cables case in South Carolina, $96 million jury verdict in a trade secrets case. I mean, I think you're right. This trend towards these massive jury verdicts is just fascinating to see. But I do think that you have to be careful as a plaintiff when you're seeking them, because they are getting set aside by the district courts and the courts of appeal at a high rate, often because the plaintiff sort of goes, swings for the fences, goes for the all or nothing, right? And doesn't provide the jury with options if the jury finds, for example, that all of the alleged trade secrets are not, in fact, trade secrets. And talked a lot about apportionment in the trade secret context, and that's the battle I'm fighting right now. But I think that's really the key. And in particular, when you're talking about unjust enrichment as well, I think many of these verdicts are for an unjust enrichment rather than for lost profits. And I think that's also critical, is to look at the making sure the jury has the tools to properly, render a verdict on what the actual unjust enrichment to the defendant has been, based on any alleged use of the trade secret, and not just throwing out numbers that don't correlate to that, because that's where you can get yourself in trouble and get your verdict thrown out.
I think we're in for a very interesting 2026 to see how a lot of these things play out.
I do think that at the pleading stage, the courts are more and more reluctant to dismiss trade secrets claims. And that also, we with the Ninth Circuit decision on early identification of trade secrets, and finding that does, for example, the California statute on that does not apply in federal court. I think that is another area where the pendulum seems to be swinging back perhaps a little bit. It had swung pretty far over to the side where the plaintiff was going to be required to identify the trade secrets with specificity very early in the case in order to be allowed to proceed with discovery. And that decision could swing the pendulum back the other way, where it's more just, if you can pass the pleading standard, that's enough for you to dive into discovery on the trade secrets claims without having to specifically identify. And so I think that's something that we're going to continue to monitor and see how the courts deal with that issue.
Yeah, I think that's, the interesting dichotomy. There are two dichotomies, really. One is California and the rest of the country, right? Because California has that statute. And then the other dichotomy is California federal courts, California state courts, because I think you're still going to see that craziness in the California state courts. And so it's going to be in the federal courts where I think you're going to see the pendulum swinging back, just as you say. I cannot wait to see how this all plays out, especially what impact Quintera has on the identification decisions in the rest of the country in the federal courts. Because I don't think the federal courts in the rest of the country have been anywhere close to where California has been. But I could see that decision helping in a number of respects. And I'll give you one example. In Ohio, as John knows, right, you've got your state court standard for preliminary injunctive relief, and that's a clear and convincing standard for trade secret claims. And in the federal courts, does the federal court apply that to state court claims in the federal court? It's a procedural rule. Or do they apply the federal standard, which is just preponderance of the evidence? And what about federal claims? Why would the state rules ever apply in the context of a DTSA claim? So I think you're going to see Quintera having impacts on procedural issues around the country in federal courts. So we'll see. 2026 is going to be a really, really interesting year, I think. Other things to keep your eyes out for in the new year are, remember, the FTC now is going to hold a workshop. They're originally scheduled for, I think it was November, I forget the date. But during the shutdown, it got canceled and now it's been rescheduled. It's January 27 from 1 o'clock to 5 o'clock. So stay tuned for that. I'm just taking this to the Massachusetts courts for a second, just given that I'm here. We've seen a bunch of decisions under the Massachusetts Non-Competition Agreement Act recently, which we hadn't seen for, the act went into place in 2018, and we had seen very few decisions. We're starting to see them more now, as expected we would, right? And so you're seeing them in state trial courts, but you're also starting to see them at the appellate level. SJC, appeals court, and stay tuned for those because those will be very informative. And then the other thing is we're also starting to see, and not just in California and the state of Washington, but you're seeing these putative class actions challenging companies' uses of their restrictive covenants. And so there's one in Massachusetts, Boyd versus Boston Beer Company in the federal court here. And then there's one in Texas brought by some anesthesia nurses. And that's Emergency, I think it's called, Emergency Health versus Anesthesia Associates. So putative class actions, right? Challenging, saying that the abuse of restrictive covenants has impacted them and their colleagues. Be really interesting. So stay tuned for those things. All right. Thank you to all of our listeners for joining us today, and we look forward to 2026. Happy holidays, everybody.
Happy holidays. Hope everybody has a enjoyable and safe holiday season.
Happy holidays.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.